Welcome to RD Investigations, Rubber Ducky Video Channel. The stage trial by character assassination strategy. To bolster its circumstantial evidence of a supposedly staged crime scene, the state relied on a strategy of character assassination, seeking to prove that Darlie was the type of person who would kill her own children. Indeed, the state's trial by character assassination started with the second paragraph of its opening statement, when the prosecution told the jury that the real Darlie Routier is, in fact, a self-centered woman, a materialistic woman, and a woman cold enough, in fact, to murder her own two children. The trial record is replete with character evidence offered and admitted for the purpose of showing Darlie's supposed propensity to murder her own sons. The following is only a partial list of evidence and testimony elicited by the state to attack Darlie's character and portray her as a type of person who would kill her own children. Barbara Jovel, a longtime acquaintance of Darlie, provided specific examples as to how, in her opinion, Darlie became more materialistic over the years. Jovel was allowed to testify that Darlie had a temper and was a dominant personality vis-a-vis her husband. Jovel was then permitted to describe specific examples of Darlie's temper in response to the prosecutor's question, what kind of things would get her mad? To which Jovel replied, mostly money. The prosecutor intentionally disregarded the motion in limine granted by the trial judge and asked Darren Routier about the fact that Darlie had breast implants. The pastor, who presided over the funeral of the slain children, was asked irrelevant questions about whether pocket knives and tarot cards were placed in the casket with the boys and whether the song Gangster's Paradise was played at the funeral. The prosecutor asked a Routier neighbor, Karen Neal, wholly irrelevant questions about the lyrics to Gangster's Paradise. Defense counsel offered no objections to admissions of the irrelevant lyrics to the song through the neighbor, and even went so far as to flippantly state in front of the jury, we have no objection if he'll sing it. On cross-examination of Luann Black, the prosecutor questioned her about the appropriateness of the lyrics to Gangster's Paradise, the first song played at the children's funeral. Even though the witness proclaimed not to know what the song was about, the prosecution was allowed to ask, so, you are not aware that it is about violent crimes? The prosecutor also was allowed to question Darlie's parenting when he asked, you mean that she let her 5- and 6-year-old children listen to Gangster's Paradise by Coolio? On cross-examination of Darren Routier, the prosecution was allowed to go line by line through the inflammatory and irrelevant lyrics of Gangster's Paradise. The prosecutor asked Darren Routier about the fact that he and Darlie bought jewelry at pawn shops and even took the children to these pawn shops on occasion. The prosecutor pointed out during Darlie's cross-examination that she did not take her children to church regularly. The prosecutor questioned Darlie about her tradition of going out with her girlfriends on the night before Mother's Day. The prosecution, in order to establish that Darlie was materialistic, repeatedly emphasized material possession owned by the Routiers. Questioning by the prosecution regarding the property the Routiers owned, including a 28-foot boat out there on the lake and new, very nice spa in the backyard. Prosecutors questioned Darren about his conversations with Jamie Johnson, a child protective service worker, about what Darlie had said to him in 1995 about being sick of everything and having trouble keeping the house clean, and about Darlie being a cleanaholic. The prosecutor implied through his question that Darren Routier told this individual, it's kind of an obsession, she will clean and clean, but the kids would be right behind her making bigger messes. Witnesses with very limited access to Darlie were allowed to testify about her alleged cold attitude toward Drake, her infant son, after the crime occurred, without establishing any relevance of this attitude to the murders. For example, nurses who attended to Darlie were allowed to testify that, even though she was fitted with IV tubes and had wounds to her neck, she would not hold Drake while she was in the hospital. A paramedic was also permitted to testify that Darlie did not ask about her infant son while the paramedic attended to her. Darren Routier was questioned about irrelevant hearsay statements he had made to a radio show host about people getting caught up in materialism and losing sight of what is important, permitting the prosecutor to ask, "That's right, that is something that you all forgot in '96, isn't it? You and the defendant. You got off the track. You got on the material side of life, and you lost sight of your 2 children for a while, didn't you?" Darren was asked to verify hearsay statements that Darlie told him she was disappointed that Drake was not a girl. Darren said, "There was no time for me and Mommy to be sexy or run around the house naked." And in May 1996, a light went on in my head saying she needs help. The prosecutor told the jury in closing arguments that, "You heard from Barbara Jovel, who is this woman's maid of honor, who has known this woman almost 10 years, who has worked with her every day there at their workplace, their one employee. And what did she tell you? It took a lot of guts to get up there, and she told you some facts about the defendant. She loves the defendant, and a few years ago Darlie was a very different person. But their business took off and her attitude started changing. She started thinking about money and became more self-centered. You know she wears the 10 rings on every finger, all the rings and earrings. She started becoming more self-centered, shopping all the time, decorating, buying boats. They bought a spa. They bought new cars, and she is a dominant personality." As to a suicide gesture Darlie allegedly made in May 1996, the prosecutor was allowed to argue, "You know, I don't think the defendant was going to kill herself. I think she loves herself too much." Referring to a videotape that was made of Darlie after the murders at her graveside birthday celebration, the state conceded the real reason it had offered this video. "I think it gives you a lot of insight into this woman. You see, this is not a picture of a grieving mother, and I don't care how many excuses you can come up with and how many doctors you can bring in here and say this is some type of Christian ceremony or she was on some Xanax or people were giving her Valiums. No, you can see how she is acting. She's enjoying herself out there. She likes the attention. She is enjoying it and gives you insight into her true character." Evidence that was available but never presented due to trial counsel's failure to investigate and prepare the defense. After her arrest, Darlie was initially represented by 2 court-appointed attorneys, Douglas Parks and Wayne Huff. Less than 3 months before trial, however, attorney Douglas Mulder was hired to replace Parks and Huff as Darlie's defense attorney. Mulder had already represented both Darren Routier and Darlie's mother, Darlie Key, during a show-causing hearing at which the state alleged they had violated a gag order regarding the upcoming trial. Mulder had previously informed Darren and Darlie Key that Parks and Huff intended to blame Darren for the murders of the 2 children. See affidavit of Darlie Key. When Darren and Darlie Key learned of this impending defense, they sought to hire Mulder to defend Darlie in her capital murder trial. Affidavit of Darren Routier. As a condition to accepting the representation, Mulder agreed that he would not point the finger at Darren's involvement in the crimes as part of Darlie's defense. During the time that Parks and Huff served as defense counsel, they had retained 2 forensic scientists, Terry Laber and Barton Epstein, to consult with the defense regarding the physical evidence in the case. See affidavit of Terry Laber at 5. Laber and Epstein's preliminary analysis contradicted the state's theory of the staged crime scene. But before Laber and Epstein could complete their work and review the evidence, Parks and Huff were replaced by Mulder. Mulder held only a brief meeting with Laber regarding the forensic scientists' work on the case, and he did not engage them or any other forensic experts to complete a scientific review and testing of the evidence. This failure allowed the state to present its theory and its expert witnesses to the jury without sufficient rebuttal by the defense. Notwithstanding the state's theory of a staged crime scene, however, there was in fact ample evidence that rebutted and contradicted the state's theory, and that demonstrated Damon, Devin, and Darlie had all been attacked by one or more intruders. Due to Mulder's decision to abandon the defense's own forensic examination of the evidence, the jury never heard any Alternative explanations for evidence, such as Darlie's nightshirt, the fiber Charles Lynch found on the bread knife, the broken wine glass, and other critical aspects of the state's physical case. The absence of exculpatory forensic evidence was so glaring that the state even went so far as to point out to the jury that defense counsel had presented no scientific evidence to rebut the physical indications of a staged crime scene. Here's the bottom line on Tom Bevel. Out there at Swift's there's another expert, Terry Labor. He is the DNA blood spatter expert who went out there on behalf of the defendant also, along with Bart Epstein. And if they want to quarrel with Tom Bevel and tell you that he is wrong, that he is a witch doctor of some sort, where's Terry Labor then? Where's the blood spatter expert? Don't you know that if he had any criticism of the opinions rendered by Tom Bevel, that just like Bart Epstein, you would see them right up here. He would be detailing for you what those criticisms are. But he's not here either, is he? And for a very good reason. There is one other thing that we need to ask also. Where are the samples from the t-shirt taken by Terry Labor? Where are they? You remember those first dibs samples that Terry Labor took from the defendant's t-shirt back in August, before Tom Bevel even had a chance to look at the t-shirt? Terry Labor, the defendant's expert, went to Dallas and was given the opportunity to take several samples from that t-shirt. Did you see those samples in courtroom at any point in this trial? No, you didn't. Don't you wonder why? You really don't have to wonder long about that question. It's obvious to you why those best samples taken by the defense, why you never saw them, and why you never heard a test result or a DNA result on any of the samples. It speaks volumes to you sometimes what you don't see and hear, and it speaks volumes in this case with regards to that t-shirt. In fact, in October 1996, defense counsel was aware of contrary evidence, but the jury never heard it. Labor and Epstein had concluded that Darlie's nightshirt indicated only minimal areas of blood spatter, and that the critical area of spatter had never been subjected to genetic testing. Bevel explained to the jury that one explanation for the absence of blood spatter was that Damon's and Devon's blood was covered by direct hits of Darlie's blood from her self-inflicted wounds. But in Labor's opinion, that interpretation required an extremely unlikely sequence of events. Labor and Epstein recommended in October 1996 that the critical areas of blood staining be tested. But Doug Mulder ignored that advice, and the jury never heard evidence from such testing. The jury also never learned that before Charles Lynch tested knife number 4, the kitchen knives recovered from 5801 Eagle Drive already had been dusted for fingerprints using a fiberglass brush composed of a similar material as the fiber removed from that knife. No definitive tests were conducted to determine the source of the fiber. Lynch could testify only that the fiber was consistent with the garage screen window. Lynch had previously reached a similar conclusion about the hair found in the same garage window screen, which he opined was consistent with Darlie's hair. In fact, DNA testing determined that he was wrong. Labor and Epstein had recommended in October of '96 that definitive testing be conducted on the fiber. But Mulder again ignored their advice, and the jury never heard evidence from such testing. Labor and Epstein also concluded that the dispersal pattern of the broken wine glass conflicted with the state's theory that the glass had been dropped to suggest a struggle. Broken glass shards discovered on the wine rack indicated that glass had been broken there. Labor and Epstein made that finding in November 1996. Mulder, however, never presented their finding to the jury. Labor and Epstein concluded that the pattern of blood spatter on the vacuum cleaner indicated that it had occurred after the vacuum cleaner had been knocked down and therefore was not consistent with Bevel's theory that the vacuum cleaner had been pushed around by someone who was bleeding. Labor and Epstein made that finding in November 1996. Once again, however, Mulder never presented their finding to the jury. Mulder's decision to cut off further forensic investigation also denied the jury the opportunity to properly consider fingerprints that established the presence of an unknown intruder in the Routier home. One of the most significant items of physical evidence that refutes the state's case is a bloody fingerprint, State's Exhibit 85J, taken from a glass sofa table between the family room where the attacks occurred and the kitchen through which the intruder had fled. The person who left that print would have had to leave it while the blood was still wet. At trial, the state's witness, James Cron, simply testified that he could not make any positive identification on the bloody fingerprint, but that it was small and was consistent with having been left by a 5 or 6-year-old child. The state's post-conviction fingerprint expert now concedes that he is excluded as possible sources of the print. All of the paramedics, police, and other persons who were known to have been at the crime scene between the times the murders were reported and the time the print was collected, except for Darlie. Yet, an independent fingerprint analysis working for ABC News has affirmatively excluded Darlie as a source of Exhibit 85J. And the renowned forensic anthropologist Richard Yontas has testified by affidavit that the fingerprint is consistent with that of a currently unidentified adult. Obviously, if the print was not made by any member of the Routier family or any of the people who responded to Darlie's 911 call, it had to have been made by an intruder. Thus, Mulder's failure to investigate the forensic evidence allowed the prosecution to falsely argue that Exhibit 85J was irrelevant and unimportant, when in reality it proves that an intruder was in the house at the time of the murders and left a bloody fingerprint. The bloody fingerprint from the sofa table is not the only unidentified fingerprint connected with the murders of Damon and Devon. A second bloody fingerprint was found on the door leading from the Routier's utility room, where Darlie found the knife. Though not introduced at trial, the second bloody print also bears enough detail to positively exclude a person as its possible source, and Darlie has been excluded as its source. Darlie and Darren have both also been excluded as a source of another patent print on the same door. Thus, these additional prints were further proof of the presence of an unknown intruder, a fact that could have been shown at trial if Mulder had not shut down the defense's forensic investigation. The jury that convicted Darlie on February 1, 1997, for the murder of Damon Routier never heard substantial evidence that undermines the state's circumstantial case against her and supports her claim of innocence, and the jury never heard a key alternate explanation for the crimes because her counsel had agreed as a condition of retention by Darlie's family to protect a more plausible suspect, her husband, at the expense of Darlie's own defense. Darlie Routier now seeks to have her conviction and sentence vacated, and a writ of habeas corpus issued because no court can have confidence in such a fundamentally tainted verdict.